Good afternoon, everyone. A very warm welcome to all the distinguished panelists, esteemed guests, and our live audience joining us from across South Asia and the globe. I am Priyansi Desai, your host for today's Roundtable Discussion Day 2, part of the inaugural South Asian Global Intellectual Property Summit 2024, organized by the Center for Development of Intellectual Property Rights and Research. Novena Development of Intellectual Property and Research Foundation. As India's first dedicated non-profit organization for intellectual property rights, CDIPR has been a trailblazer in promoting IP awareness in education. With a vision to democratize IP knowledge, CDIPR is committed to empowering creators, innovators, and businesses to effectively harness the intellectual assets. Our efforts are anchored in fostering inclusivity, sustainability, and economic resilience through innovative IP practices. The media partner for today's discussion is LiveLaw. This summit is a month long celebration of intellectual exchange and innovation and has brought together global thought leaders, policymakers, academicians, and industry professionals to discuss the evolving landscape of intellectual property rights in South Asia. Today's roundtable discussion is pivotal as it aims to address the challenges under the theme Bridging Borders, Strengthening Intellectual Property Frameworks for Innovation, Climate Resilience, and Cultural Preservation in South Asia. Let's embark on a journey of knowledge, collaboration, and solutions for IP in our region. For the first session, we have Ms. Uza Fatima Wahida. She is the head of the Department of Law, Faculty of Sharia and Law, the Maldives National University. Ms. Uza will discuss the IP barriers and opportunities for small island nations. Ms. Uza, the floor is yours.
Priyanshi, ma'am is not ready yet. She'll go in a while. Till then, we can have other speakers on board.
Okay. So we can move ahead with Nalin sir. So for his session, we have he is the DPIIT IPR Chair Professor of the Indian Institute of Technology Patna, and sir will illuminate us with the IP enforcement challenges in combating piracy and counterfeiting. Sir, can you please begin?
Yeah, so as we all know that uh, intellectual property rights are becoming one of the major issue for the countries in terms of cooperation, in terms of protection of IP, intellectual property rights, and lots of conflict we are happening among the countries. So dispute settlement body cases, which is available on WTO website, is uh, uh, one of the platform where we can also see there are many disputes related to the countries, among the countries, and where the other countries are also the party in those disputes, mainly related to some of the cases I have seen that it is related to patent, trademark, copyright. That is the domain of intellectual property rights. So at the country level, we find that these are the issues within the region. For example, South Asia or East Asia. Within the region, also we are finding that countries are having some type of conflict. And similar trend we are also finding within the country. So inside the country also we are finding that a firm is fighting against other firm, a firm is complaining the mishap happening with other firms. So one of the issue which I have also highlighted in our last discussion on this global intellectual property summit where I have discussed about how Dabur, one of the uh, Ayurvedic producer, Ayurvedic medicine and product launcher in India, they are basically they have faced basically the problem when the online different online platforms have started selling Dabur products. So, in the name of Dabur, there were many online sellers, those who were selling the products, but Dabur had not authorized them to sell the products. Neither they have taken materials from the Dabur. So, from where these products comes, Dabur is a established brand in India, and if Dabur is unknown about this type of infringement, or you can say this type of online sale of the product, then uh, a premium company from India is facing this type of problem. This leads to understand the issue related to the infringement within the country. So, if a farm is not safe within the country, uh, how a farm can also be safe outside the country? Because your way, see, the problem with trademark or problem with intellectual property infringement is that infringement, the cost of infringement is very low compared to searching that who is doing what in which area, in which country, in which region, in which geographical area. So that becomes very difficult for the patent owner to find out who is basically infringing the rights of patent owner, who is basically infringing the rights of the trademark owner, who is basically infringing the rights of uh, basically the copyright owner. So that makes the entire process very very costly for the owner of the intellectual property rights. And that is the issue when enforcement of patent rights and infringement of those intellectual property rights becomes very important for the country to control. So, given this background, when we are discussing about different intellectual property rights, if we see here the copyright and related rights infringement issue, when we were not very much digital uh, in our services, today we are very much digital in our services. So a book published by a firm can be copied by other firm, or it can be also sold out on different online channels. One of the major important case which I have seen in India was the Kindle version of Nirmal Verma's book, which was available online without taking consent from the Nirmal Verma, one of the Hindi writer who has received the Sahitya Akademi Award long time back. So when the family raised this issue with the Rajkamal Prakashan, then Rajkamal Prakashan was not in the position to defend this because there was no contract between the author and the Rajkamal Prakashan for selling these books online on the Kindle version. So, varieties of this is one case. We are also finding that there are many other cases where lots of intellectual property materials are sold out without informing the author. And when authors are not given the consent, when author has not been in the has not kept in the limelight, or you can say if they are not well informed, then what is happening is authors are losing their economic rights or incentives. So why intellectual property rights and its protection is important? Because intellectual property right protection gives an economic incentive to the owner of the intellectual property. So the moment lots of infringement is happening, the moment uh, one is ready to pirate others' work, one is ready to infringe the rights of others. And if we have a loose intellectual property environment and loose intellectual property system in the country, what is happening is the real owner is basically the loser, and those who are basically the free rider, who has not done any research and development, who has not written a book, who has not having any ownership on a product that is having the trademark, they become the real gainer in the market. So, so if that system exists, if you are continuing with that type of mechanism in the country, what is happening is you are basically discouraging the intellectual property rights to go ahead, discouraging the intellectual property rights to come up in the country, and then you are having a very, you can say, disincentives for those who are having the intellectual property rights. So the moment you are having the disincentives for the intellectual property owners, uh, you are not making your entrepreneurs very uh, sound enough, because they will be, you have the entrepreneur, but that entrepreneur is busy in infringing the rights of others. They are not basically the owner of any new item. They are not basically the owner of any new product, but they are basically the pirates, the entrepreneurs who are basically depending on the piracy. So how long you can continue in the market if you are basically uh, busy in piracy, if you are basically uh, uh, you are trying to infringe the rights of others. So this type of mechanism, this type of arrangement is not going to give you a right hand, a right choice in the beginning, and not in the future also, because ultimately after some time, today and tomorrow, you will be caught and your business will be suffering a lot within the country and outside the country. So, given this condition of infringement of copyrighted material or patent products, or maybe the trademark related items, this is high time that when a country like India has to move ahead with lots of economic power and faster economic growth, we cannot achieve faster economic growth as long as we are not protecting the intellectual property rights properly. And this intellectual property right protection is not only for our local form. The same we have to do it for other international forms coming from other part of the world, because more you are busy in protecting the rights of others, others will also have the faith in investment in your country. So more recently, I have also supervised a thesis where I have where one of my student, Mr. Saurabh, has argued that how intellectual property rights and investment has a proper linkage. So the countries where, with the countries, India and India's investment partners have signed various agreement, and we are sound enough in protecting the rights of intellectual property. And in the countries where we have received investment in R&D, and where we have the pact between two countries for protecting the intellectual property rights, we were having lots of investment coming from those countries. So investment and intellectual property works together. It is not like investment for an investment coming from other part of the world is going to kill the intellectual property in the country. Because these days, any country, if a country is signing comprehensive economic partnership agreement with other country, they really takes care of these aspects, not only the trade, not only the investment, but also the intellectual property rights. So, gone were the days when we were only looking for the mutual trade agreements. Today, we are not only looking for the mutual trade agreements, we are also looking for, apart from what other aspect we can include as a part of the economic partnership agreement. So, countries agreement uh, which is more focused for the economic partnership, and instead of a free trade agreement, now we are also looking for a major economic partnership agreement. So, such situations are basically bringing countries uh, more concerned about and more serious about protecting the intellectual property rights. And in this scenario, when we are having this type of global intellectual property summit, we are also very much concerned about how South Asia is looking this particular aspect, because South Asian economy till today, it has a limited contribution in the field of patent ownership. India is now, compared to past, India's contribution in terms of patent application has increased too much. In terms of trademark also, we have a large number of registration happening. But if you will see the geographical indication registration, I was going through the Germany data, the data on GI registration in Germany. It is a huge registration which Germany has done, Japan has done. Entire South Asia is not equal to the GI registration which Germany alone has done. In terms of population, we are much ahead, much bigger population in South Asia compared to Germany, much bigger population in South Asia compared to Japan. But in terms of GI registration, we are far, far away. We are far below the level of GI registration happening in Germany and Japan. These are the developed countries. Germany and Japan is a developed country. Why they wish to register GI products? Uh, because they understand the importance of geographical indications, which has long run impact for the society. So if you are registering the GI products, you have a long run impact of those registrations for the local society, because it creates employment, it creates economic development in that particular local geographical area. But within our country also, very limited, close to 400 only, we have the GI registered products. That includes some of the products outside India, from other country also. So that shows that even being a country which has lots of employment is still generated in agriculture, and given the condition of many geographical indications which is basically rooted in our culture, in our society, we are not really fast enough in registering those indications or those products. So Banarsi sari is not only a textile item, not only a textile product. It is also a product which is linked with the uh, with the culture of Varanasi, a tradition of Varanasi. It has the long history, which cannot be denied by anyone. But in the name of Banarsi sari, now some of the countries like China is also selling Shanghai sari in the global market, and due to the cost effectiveness, India has to compete with those saris. Uh, and uh, Only the real customer, or the customer which is really having the information about what are basically the importance and what are basically the distinction of Banarsi sari, only those customers are able to make a difference between the real Banarsi sari and the fake Banarsi sari, and then only they can buy it. So Banarsi sari is one example where we can stop the infringement of other countries, or other countries' market access for selling those Banarsi sari. So for that, since we have registered and we have a tag, and that tag can be placed on the product, and that can protect the intellectual properties of those community and society. So this is one way and one example to see that how infringement can be stopped through the ownership and through the registration. Since GI registration is not for the individual but for the community, it is the community which holds the GI ownership. So a particular geography has the ownership of a particular product. So uh, a small product, when it was registered, we were not aware. Today, Madhubani painting, uh, which is also sold out through online platform and through the government websites. Upendra Maharathi Sansthan in Patna is trying to help out those artists to sell out their products online. So when we have such products, and when global community is aware that what is this type of painting, and if today and tomorrow somebody has started printing Madhubani painting and saying that this is really the Madhubani painting, since we have the registration and we have the GI tag of this particular product, we can really prove that what basically the difference between the GI product and non-GI product, GI Madhubani painting and non-GI Madhubani painting. So in total, if you will see one product and two products and its importance for the community, we can see that it has the limited reach out and it can only help this community at the very limited level. But suppose if India is having 5,000 and 4,000 such products, and every products, maybe 20% products or 30% products are facing infringement. Today, we don't know which product will be facing the infringement, IP infringement. We don't know, because wherever will be the global demand, there will be infringement. Infringement is not happening for those products which has no demand. Infringement is happening only for those products which has the demand. And since we are in a global village, so any product, if it has the growing demand, that will be basically the case of infringement. So we must be taking serious note through this summit that how we can stop the infringement and what action the policymakers, government, think tank, social bodies can take. The lots of awareness is going to help us, and the previous cases warns us that whether it is basmati rice or it is Banarsi sari or Madhubani painting or maybe some of the patented items or our trademark products, if it will not be properly protected, then the economic incentives of the owners are going to be taken away by the free riders. We have to stop the free riding in lots of economic activities, and we have to make India ready uh, for taking the global investment and receiving the global investment. And manufacturing activities can be done together, not by our own investors, local investors, but bringing international investors again in the line, in the mainstream of the Indian manufacturing activities. And for that, we need the protection of intellectual property rights. So protection of intellectual property rights is
So there's some network issue at your end.
so if that protection is not happening, uh, then the country may miss the new investment, may miss the new manufacturing. The country may also miss the new opportunities in terms of trade. So this is my short presentation on this particular topic. I will be staying uh, in the summit for some more time, listening some other speakers also, and if some questions happens, then I will also take those questions. Thank you.
Thank you so much, sir, for your insights. Now, for the next session that is titled The Future of SMEs Leveraging IP for Growth, we have Dr. Pankaj Kumar, who is the DPIIT IPR Chair Professor at the National Law University and Judicial Academy, Assam, India. Dr. Pankaj will shed light on the role of IP in driving innovation and economic sustainability for SMEs in South Asia. Over to you, sir.
Thank you, Priyansi, Soumya, Dia, and thank you, Center for Development of IP and Research, Novena Development of IP and Research Foundation, for this opportunity. As Nalinji discussed the challenges, particularly the IP infringement, and it's very difficult to resolve such issues by startups and MSME because they have limited resource, limited fund, isn't it? Particularly, he highlights geographical indications and related challenges. Yesterday, we have one meeting on GI, and we noted there is a really huge challenges in the IP, including all kinds of IP. It's not only GI, but patent, design, trademarks, everywhere there are challenges. See, there is hardly any people who appreciate listening challenges. I am glad you people giving opportunity to we people listening the challenges. and the possible solutions. Otherwise, even your family member will not appreciate you, the problem you facing, isn't it? So see, this is really wonderful opportunity here to discuss the challenges. Otherwise, even the concerned person, the government authorities hardly talks or appreciate such kind of challenges. And that's why this is the main reason why we have challenges. Otherwise, such challenges must be disposed at the earliest. See the stakeholder. Who are the stakeholder? GI. Suppose if we discuss GI first, so we can continue with Nalinji point. The stakeholder are the society, the key person who are eligible to apply for such GI. There are already so many GI registered so far. Still, there are huge potential to get further new GI. Most of the time, we noted that there are hardly much authorized user. Try to understand the concept. GI is for the society, the concerned members in that society who are doing such business since long, since generations. After GI registration, legally, no one can do commercialization of such GI tagged items without authorization. So every such members need to be an authorized member. And that's why in GI there are concept of two kinds of registration. One is registration of GI goods and another is registration of members as an authorized user. So in many cases, we noted there are hardly much authorized user. So this is not so exclusive for a few person or one entities. And that's why this is different than other kind of IPR. Anyone can apply for any kind of IPR, but not such case in GI. Only the society can apply for GI. So all the members of such society may be eligible to use such GI tag. But many times it is noted that the stakeholder, the key person, the proprietor, the applicant itself hardly much promote such camp, adding more member in that society. So the main purpose behind the GI can't be fulfilled. There are hardly few persons under the society. They are monopolizing over such kind of things. They are doing all such commercial advantages, exports, etc. But still, the society itself. Society means, what does it mean? The association of the concerned person. So the persons who are doing such business since generations unable to use it legally without being an authorized user. So this is one of the challenge under GI. I think due to limited time slots here, most of we people, the participant might aware the importance of IPR, why we need IPR, what are the benefits of IPR. So rather than focusing, if you allow, may I discuss more about the challenge part? Generally, government authorities hardly appreciate listening the challenge part because most of the time it is associated with the different government officials. So see, this is just like जागो ग्राहक जागो. आपने ग्राहक जगा दिया, बाद में जब लिटिगेशंस आई तो वो डिस्पोज ही नहीं हो रहे, तो देयर इज नो एनी बेनिफिट्स ऑफ जागो ग्राहक जागो. Similarly, there are a lot of IPR awareness program. Now there are a lot of filings. If office unable to dispose it timely, so what's the benefit of such IP promotions? Most of the time people don't appreciate such kind of criticism, but we must take such criticism as a positive criticism, and we have to admit, yes, these are the challenges. Otherwise we can talk always on such kind of things, no one can answer, no one can respond. See, last year the target given to IP offices, particularly for patent, is 1 lakh patent may be granted that financial year 2023-24. and around more than 1,15,000 patent has been granted. So, because there are several issues, we can't discuss all such issues. You can anticipate kind of things and see the public cry, the stakeholder cry. So they dispose even more than the target. Over 1,15,000 patent has been granted. But see, why it cannot be continued? Whether we have lesser number of patent now? No, we have more applications, but still disposal is very, very less. I don't think we can dispose even 1 lakh patent this year, this financial year. If we ask the justification, so there is one word justification. Can you guess? Quality control. Isn't it so vague? Isn't it so vague? But again, see, deadlines. All time, all the deadlines are for the applicants, the agent, isn't it? Is there any deadline for the government officials, IP offices, patent office, trademark office, copyright office, design office? So they are awaiting disposal since years in many cases. There are some examples where disposals are in time, like 6 months or 1 year. So most of the time they are giving examples that we have granted such patent or such kind of things within 6 months. So 6 months is the ideal time or what they are doing advocacy or appreciating their own officers or offices. But if we can talk in percentage, then you realize the exact position. Don't go for numbers. Find the percentage. Then you can really appreciate what is going on. So things are not appreciable. There are cases which are awaiting disposal since years. And no one seems responsible. They hardly respond emails, forget verbal communication. Earlier, see, if you like, I can continue. Otherwise, there are a lot of things to discuss. What are the benefits of IP? See, what I note in focus point, identify core IP challenges in your country, propose solutions and actionable strategy, and share example. So I'm focusing on just that point. If you are aware about the system of trademarks, how much time needed to examine trademark application? It's a hardly matter of few minutes. Sometimes even years taken to examine such applications. Should we appreciate it? Isn't it there some deadlines for such offices? There is no any issue of fund. There is huge fund. They are generating itself huge fund. Where is the problem? Hearing awaiting since years. The life of professionals is pathetic. All the times applicant ask what's the update. Since there is no any update since years, how to handle clients? And most of the time such type of problem faced by small entities, micro, small, medium enterprises, startups and small practitioners. So it seems fishy. Such all examples, illustration itself indicates something. So do we need to pinpoint it? Earlier, whenever we file any patent application, every Friday such application published and we get intimation on the email, SMS. since sometimes there are few months, there is no such intimation. Our application has been published or not? Should we try checking online all the Fridays whether such application has been published or not? They have dedicated software. Why not? Why such services is blocked? No one asked to have such services. They itself started such kind of services. फिर आपने वो सर्विसेज बंद कर दी विदाउट एनी नोटिफिकेशन, विदाउट एनी रीजन, विदाउट एनी ग्रांट. सो नो वन अवेयर व्हाई सच notification has been stopped. So many times might be people not aware what is the status of their application. And so this is a voluntary step, optional request for early publication. Otherwise all such publications happen after expiry of 18 months. So applicant need to pay extra so that their patent application have to be published in time. Because next step is examination. And no patent application examined before such publication. And this is the reason applicant need to request for early publication so that in time their application has to be examined. Again, if there is a delay and there is no any intimation, so without involving any further resources, any funds, why such kind of discrepancies or lacunas? Why they are not cooperating? So no one is asking. Because why no one is asking? Because large companies have big firms, so they manage the things. They have hardly such problems in their cases. All such problems mostly faced by small entities and startups. They themselves hardly communicate with IP offices, and they hired most of the times independent practitioners. And most of the times independent practitioners don't try to express their grievance against such offices, and that's why such problem persist. So these are real challenges to startups and MSME. So what are the solutions? The best solution is all such startups and micro, small, medium enterprises should be vocal. They need to communicate with IP offices, because no practitioner can help after some extent. They have to be practiced under such offices. It's only the applicant, the startups and SMEs, they can freely raise their voice. So see, there are cases in patents which are pending since more than 5 years. And see the delay. For every delay, at the end of agent, the professional or the applicant side, there is a requirement of petition along with heavy fee, penalty. Is there any such penalties or petition by such officers or officers? No. So there is a timeline for request for examination, 48 months. So now it reduced to 31 months. So if anyone, even by mistake, miss this deadline 31 months, they have to petition along with government fee. And for a small entities and a startup, this fee is 10,000, and for large entity, this fee is 50,000. So suppose there is 4 months delay. Maybe someone forget that timeline has been reduced from 48 months to 31 months. So after few months, if they realize they have to request for examination, their examination request will not be accepted until they request with petition along with such penalty. So they have to pay around more than 2 lakh rupees for such penalty. All such government fee will not be reversed once you paid, no matter whether your applications disposed by mean of acceptance or rejection. Amazingly, in case due to portal issues, sometimes there are multiple payments. Most of the times we experience in online portals that we get reversal within few minutes for failure of transactions or such double transactions. But in such case, there is hardly such reversal. You have to request, and there is no any designated person which is notified so that public can follow up. So there is a huge follow up to get reversal of such double payment. So I am not demotivating any small entities and startups. We have to realize, yes, these are challenges. And the best way to resolve such challenges are, all these are petty challenges. This can be easily solved if there is a positive mindset. If they try to cooperate, so all such problem easily solved. So until unless startups and SMEs vocal, there is a social media, the best way. If they don't respond by email, we can use social media. We can't expect such initiatives from agents or IP professionals. नदी में रह के मगर से बेर. So we have to realize again, every controllers have a team of examiner, and most of the time new examiner are not properly trained or they are not well aware about the norms. They are asking petty things like signature, verified signature. How you need to submit some evidence that this is a real signature, original signature. How can we authenticate? So far, no one raised such type of petty objections. All such documents filed online by digital sign, still there are some officers, they ask physical documents with physical sign. So many times people, what they do, they need to print out the forms which are generated from their own IP portals. After printing, they have to sign it, scan it, and again re-upload it. Nonsense. This is not the purpose of online filing. Again, as per the law, it is clearly mentions that all such document which is digitally signed, no need to submit hard copies or original document until the office asks the same. It is again noted that sometimes such officer ask penalty. You didn't submit the original document in time offline. So case to case basis, person to person basis, we realize, we noted there are ample cases. So this is one side, but another side, IPR, this is a wonderful opportunity for startups and MSME because these are legal monopoly, exclusive rights. Generally, we don't use this word legal monopoly or monopoly because the word itself is a negative word, monopoly. So better we use the word exclusivity. So they can exclude any person, no matter how big the person. Those who have rights, they have authority, they can exclude anyone. So all the person interested need to take prior consent from the right holder. So I think such summits maybe make open so that there may be some interaction. If someone like to ask some questions or interact with such challenging, even there may be some person who have some real experience of such challenges. They can discuss what's the problem they really face. See, being a DPIT IPR chair many times public relates we people from the IP offices. We are not directly linked with IP offices. IP offices also worked under DPIIT, and we also works under DPIIT. But we are not directly involved in IP offices work. Fortunately or unfortunately, being such position holder, we received many times such challenges from the public itself. Otherwise, how can I speak about on such multiple challenges relates to different kinds of IP offices? So there are several communications made. Still, it's very difficult to get the solution, and that's why I promote all such small entities and a startup. They have to be communicate. They have to be start communicate. So far, they never try to communicate with such officials. If they start such communication in social media, if they share the screenshot, what's the problem they face, they have to be realized. Yes, there are problems, and once such people start speaking, I think problem must be solved at the earliest. So thank you very much for your patience hearing. If you like,
Thank you. Thank you so much, sir. We move on to the.
one thing more. Uh,
Yes, sir.
all such certificates nowadays, patent certificate, design certificate, all such certificates online, and most of the time such applications made by the professionals, so they use their own email ID, and many times there are some miscommunication or non-cooperation between these parties, applicant and professionals. So once such applicant try to communicate with such concerned IP offices for their certificates, they hardly respond communication to applicant. They hardly release certificates to applicants. Amazing. The agent, who is the big, whether agent or the applicant? It's the applicant who is supreme here. So offices prefer to communicate or arranging the documents to the agent only, not the applicant. Applicant at any time can change the agent. So there is no any problem on the basis of power of attorney. They can change it anytime. So all such officers must realize they must cooperate with the applicant. So no matter they have changed the agent or not, whether the agent is communicated with the office or not, they have to serve on applicant email ID such a soft copy of the certificates. But hardly any of such offices issue the certificate to the applicant directly. They ask, where is your agent? On our records, we have agent email ID. We can serve on that email ID only. So do you think such a response can solve the problem of the applicant side? So there are so many challenges. We can't discuss all such challenges in such 10 to 15 minutes. Thank you very much.
Thank you so much, sir. As we move ahead, the next session is titled as Emerging IP Challenges in the Small Island Nations, and this session will be headed by Ms. Uza Fatima Wahida, Head of the Department of Law, Faculty of Sharia and Law, the Maldives National University. Ms. Uza will discuss the IP barriers and opportunities for small island nations. Ma'am, over to you.
Thank you so much for the kind introduction. Where Maldives is concerned, the country has enacted some laws and regulations aimed at strengthening IP protection. However, compared to other South Asian countries, it is far lagging behind. In the efforts to embrace IP protection, in 2010, a law on copyright protection was adopted, which was followed by a copyright regulation in 2011. However, specific legislation on trademark, patent, and other areas has not been developed so far. However, in regards to trademark The said protection is sought by publication of cautionary notice in a leading newspaper. This kind of serves as a notice to public that said invention belongs to someone, and if required, passing of remedy shall be exercised in the court. So, where our South Asian counterparts are considered, the Maldives have very limited laws on IPL. However, one thing which is of course a milestone in the Maldives was that after 14 years, an amendment came on the Copyright Act in early December. This was considered to be a milestone, considering that broader protection scope was there, and also it introduced simplified copyright ownership. Formal registration is not required for copyright ownership. However, creators now can voluntarily register their works with the relevant ministry. Also, in case of legal recourse and compensation, now right holders can take legal action against copyright violations, seek compensation for damages caused by infringement. In this regard, criminal penalties are also introduced in the Act now. Also, extended copyright term, that is copyright protection, has been extended from 50 to 70 years now, which now aligns with the international standards, and this can ensure long-term benefits for creators. Also, the law actually clarifies additional circumstances where copyright works may be used without infringement, including fair use of educational and research purposes. So having effective and strong legal framework is very beneficial to our creators, and it can foster entrepreneurship and boost creativity in the nation. However, at the same time, awareness and education, a high level of awareness and understanding of IP laws is required among the public and the businesses. Entrepreneurs and creators are unfamiliar with mechanisms to protect their intellectual property. To make it more complex, the digital era has introduced new challenges to the protection of IP. Copyright has to adapt to the digital age, with new provisions and regulations being introduced to address issues such as online piracy, unauthorized sharing, and illegal downloading. But then again, digitalization has brought about new creative expression such as digital art and online content creation, which requires new considerations. Online piracy and copyright infringement has become widespread here, resulting in significant losses for businesses. Copyright issues in e-commerce platforms. We do have a lot of online businesses here. So e-commerce platforms often face copyright issues related to user-generated content, such as product description, images, and also reviews. With the rapid advancement of technology, new challenges and trends in copyright protection for e-commerce are emerging. One such trend is the use of artificial intelligence and machine learning algorithms to detect and prevent copyright infringement. So here I'm only speaking about copyright here in regards to e-commerce, but at the same time, I think related laws such as e-commerce laws or other laws can also benefit here. However, unfortunately, we don't have any e-commerce laws as well. Therefore, it provides more opportunities for infringements and also other legal issues. Given the increased number of social media users in the Maldives, so where when compared with a lot of South Asian countries, Maldives have a very high number of users. So, of course, legal issues related to social media platforms are incumbent. This includes sharing photos, videos, music's written content that is protected by copyright law. But usually users share content without obtaining necessary permissions and licenses. So how do we address these things? Of course, we see that platforms have implemented various measures to address these issues. such as content filtering systems and copyright infringement reporting mechanisms. However, the fast-paced nature of the social media makes it challenging to effectively monitor and control the sharing of copyrighted content. Another very important issue, very relevant issue is artificial intelligence. Artificial intelligence has had a significant impact on copyright law. With the advancement of AI technology, there are new challenges and considerations that arise in relation to copyright. So, we have seen that copyright law traditionally grants exclusive rights to human creators, but with AI generated content, it becomes unclear who should be considered the author or owner of the work. So, one of the main concerns here is the question of authorship and ownership, as AI algorithms can autonomously generate content without direct intervention. It becomes more challenging to attribute authorship to specific individuals. So, to address the emerging challenges and issues related to AI and copyright, legal frameworks have developed. These frameworks aim to provide clarity and guidance on the ownership, protection, and use of AI generated content. So, interestingly, some proposed solutions include granting copyright protection to AI generated works under the name of organizations or individuals who own and control the AI system. Some other suggestions include creating a new category of copyright specifically for AI generated content with different rules and regulations. So, from these emerging issues, we see that even though IP laws have been adopted, it is not sufficient. It needs to be evolving and reformed to keep abreast of new technology. So, even before the digital era, enforcement of IPR is very complicated as it can occur across borders. However, where cyberspace is involved, it becomes more difficult as perpetrators are in different locations, making enforcement more complex. Also, in regards to cyber-enabled copyright, because of the different jurisdictions, because different jurisdictions have different laws, rules, regulations, to determine infringement of a particular work is also difficult. And it becomes more complicated to actually have a redress for these kind of issues. So, learning from experience of other South Asian countries, I propose that having a separate intellectual property law from administrative and legal systems by establishing specialized courts or semi-specialized commercial courts would be highly beneficial to the Maldives, because we do lack a very prominent legal system. We do lack expertise. There is time. It is very time consuming to actually go through the court process, and so far there has been a very few cases which has actually gone through the court system. Secondly, having a harmonized intellectual property law. So far, the Maldives have not adopted any international instruments. So, having a harmonized intellectual property law through adopting international instruments and conventions is very essential for the country to address the emerging issues as well as the traditional copyright issues. So, where Maldives is concerned, urgent reforms are needed. It should enact specialized laws such as trademark and patents and GI as well for currently unprotected areas. Also align existing laws with international standards, increase training and resources for enforcement of officials. The evolving needs and considerations for IPR protection require a multifaceted enforcement approach involving different stakeholders. So, domestically as well, different stakeholders need to be having a conversation or a dialogue to address these issues. Internationally as well, for a cyber-enabled intellectual property investigation, A lot of different stakeholders from different countries needs to be working together to actually resolve such an issue. So new initiatives from government, regionally, internationally needs to be adopted to address the emerging issues of IP protection. But for now, transparency and awareness across governments, the private sector, the public can help to safeguard IPR domestically and globally through sharing the information and best practices in the education of consumers. Thank you.
Thank you. Thank you so much, ma'am. Now, as we move ahead, I would like to call upon Professor Dr. M.R.S. Murthy, the DPIIT IPR Chair Professor at the National University of Study and Research in Law, Ranchi, India. Professor Murthy will address the role of IP in South Asia's sustainable development. Over to you, sir. Sir, your mic is on mute.
Yes, thank
Yes,
you.
sir.
Good afternoon to all. Am I audible?
Yes, sir. Yes.
Right. 1 minute. Now, so I must now congratulate the organizing team for conducting such a must know needful and required thing which will contribute for regional development and global development. So firstly, I must appreciate the organizers for making the efforts for doing this line of small. Ultimately, everything will take a shape after making these kind of little tiny steps only make the big huge construction. Like human body is built up of cells is more significant. If one cell get damaged, the human suffering will start. Such a huge body of means the heavy weight also will get affected with a small cell effect. So that's why we must see that level of working, being means academicians and practitioners and professionals. So the significance requires to be discussed reason. I'm going to just to touch on because of the given limited time of 15 minutes timeline if I'm just keeping up. Is it that okay, madam?
Yes, sir.
So now 41, maybe around 55 I will be permitted. Right.
Yes, sir.
So till to that time, I'll try to give a glimpse of the global village working condition, and in that where the SARC able to give a picture, and along with other regional groups also, I'll give an indication. So by that later individual, yes, every country will have their line of difficulty, including America or France or means no jo UK, Japan, whatever, whomsoever, China, whomsoever standing on the top, they are also having their own individual difficulties and problems. Only thing is one is better than the other, and one day we are also beyond 100 ranks, and today we reach it to India reached to 47 second rank. But when you see some of these information which I'm going to share, you can get to know that how we can improve and how we can work out. It is only thought provoking information, nothing else to make any criticism to any of the people as such. I'm not mentioning any specific nation, I'm mentioning only regional groups. Like there are so many, European Union is there, ARIPO is there, now North American continent, one regional NAFTA is there, and ASEAN is there, so SARC is there. So this way, there are so many regional groups are there parallelly working for. CDC is there. So there are plenty of groups, more than 20, 30 groups. As per my knowledge, I have more than 20 groups are working in different regions for their regional coordination and development. Why I am saying one day nation, that means kingdoms used to work within that means no dynasty of that regime of a particular specific region which is limited to group of villages or next to that up to a segment of region. But today in the global village of 21st century working, we are crossing the borders without any barrier because humankind is one and the same. And now today we are talking about UFOs and other aliens are getting in and out, and we are going to have some difficulties, variations, or benefits. We don't know what it is going to happen, but other planets also do have such kind of. Then we must have, then in the Earth itself is one group, and other planets may have another conditions, another group. Like tomorrow, if the other planet groups able to identify, things may be falling different. By that situation, already a 40-50 years of exercise, if you look in, after GATT development, that means 1947-49 development, the things was shapen into a different form because of First World War, Second World War difficulties which was experienced. Barrier removal is required for humanity development. So in that situation, in humankind development, if you see from ape to man, so that days ape in animal living, as per history, whether you accept for 3,000 years, 5,000 years, 10,000 years, whatever way line or timeline you are talking about. So in that timeline development, when you look upon, the things are developed with intellectuality only. Civilization, society development, everything is happened only because of intellectuality. That too, human intellectuality is the causal reason of driving the development of the society or the planet or the universe in a good direction. Only thing is, once you get to know, then only we can think about and work out. In that process, if at least you take from Mesnojo existing today, we are in 2024 and ending, and 25 is starting. By this calculation also, if you are able to look upon, by 2000 years of development, this is very historical, and we have 100% information and evidences of the related. Up to this 2000 development, if you look in, I give one small testimonial information which you can test it from net and other sources. Like recently we experienced a COVID problem. This is not a new. Very periodically, these line of problems are regularly happened in history. History is indicating that. And if you compare with 100 years before problem and 100 years after problem, today's 2020s means COVID-19, that means 2019 when we affected, reason that was coined as COVID-19, and the plague which we experienced 100 years before. There are history study also published in Indian. I am mentioning about Indian condition. Likewise, every country is having the line of history. So when we see in the development of this process to combat this difficulty and understand this difficulty, because it erupted and no one able to understand what is this problem and how to work out with it. Similar way in plague also, the same manner, people left the villages and moved to different places, and by that way they tried to work out. It took a period of 25 years to combat properly, right? In 1908 onwards to till 1925-28, it happened, right? Whereas in the case of today COVID, it happened in 19, and we able to have the vaccine and alternative medicines working within 1 year time. Not even 365 days completed, things able to come in. Identifying, we already completed the identification, able to combat, how to work out. Maybe directly we could not able to make out the treatment with immediate effect. Reason, we made alternative method of vaccine development, and through that vaccine we can at least immunize the person not to infect or affect with that kind of situation. So that is a way, and other precautionary measures able to make out. Otherwise, crores of people, 50% of the world population might have washed out. If you see the statistics of the COVID infected people, so that is more than 50% infected, but they are not suffered. They just, because of some precautionary measures and treatment methods, we able to come out of that difficulty. So in that situation, I am just giving 25 years situation today able to reach out by 20, less than 25 months. 25 years, 25 months, not even 25 months, less than 12 months itself it happened. So in that comparison, it's a huge development. Why this huge development in 100 years it happened? I give you one example. For penicillin injection, that means which is now outdated, which is no way workable, because every human body today taken birth is having the immunization more than penicillin capacity. That's the reason why it is rejected to carry today. So that was happened 100 years before, like 150 years or 150 years or 140 years around it happened. By that time, for invention of penicillin, there are 5,000 lives experimented for that invention development. But today, for COVID, not even 5 lives taken away for experimental purpose. But this is the enrichment of our skills developing also, research purpose also. We are now developed the research categories into 4 universally. Like means no jo 4 category of research levels, dry lab experiment and wet lab experiment, and then next to that voluntary experiment, or next to that means no jo the live experiment for the patient at the 4th stage, which will be 100% safe and protectable and revivable. So in that manner, but in the 150 years before, we directly used to experiment and find the reaction from the human being. But in that alternative, today we invented a guinea pig, and with that guinea pig we are experimenting how the reactions will be happen, and by that way we are trying to, at the third level itself, we are clarifying these aspects. At the second and third levels itself, we have been fixing the problems without any life experimenting into that, right? So in that way, our technical skill also time to time sharpening, improving, and that's the reason why this all happened, because of global village working. This global village working was started in 19th century, but that was not succeeded, and it was struggled for several years. And first and second world war give a practical lesson that because of these individual fights and human being is suffering a lot, we must come to a conclusion reason. We got the GATT, and after that international development, there are multiple documents are clashing with each other reason. WTO brought in 94. So by 94, today, the concept of global village, if you see in UN also, as on today, UN is having 194 members or so. So out of these 194 members, almost all are members. Rest of the members are given opportunity till 2033 to become TRIPS compliance. So in that manner, now we can consider that global village is in one gamut. There is no difference of opinion. They are all in one platform. But at a time, 2000, this 200 countries or 194 countries cannot be instructed in one go, because they are not geographically equal. They have their ecological differences to each other and regional differences to each other. We continentally divided, and even within the continent also, there are again regional differences with each other because of the conditions. By that way, for collective growth, no doubt objective of collective growth of the global village is correct, but without balancing of each other's differences in a required manner, especially, that collective achievement is not possible to achieve. Even whatever America, total American revenue also spent to whole world, by then also it is not only America, all the developed countries put together, all their earnings they spend to rest of the countries also not able to achieve the goal unless regional coordination strengthen. And by that way, local people can give absolute solution with 10% of that spending, where a foreigner is coming and spending on us for the same improvement, they need to spend 10 times more. So by that reason, now WIPO also recognized and trying to just give upliftment of regional coordination to enhance. And by differences of regional, different reasons like territorial differences, other kind of clashing conditions, we are differing. But because of that difference, what we are losing is the humankind life is how much? Maximum 100, years, whatever the scientific proof is. So within this 100 years, person need to experience whatever is better possible rather than whatever is worst possible. This is the better thought process to be considered valid. So in that way, the GATT was developed, and today WTO said out of these territorial differences, let us have some line of common opinion, and by that we like to transform. That's why in the name of trade, intellectuality also looking in the name of trade rather than integrity and dignity of individual nations differences to each other. So by that way, now equalization was brought in regional for SARC. Because we are discussing on SARC level, I just make one point: how effective today's SARC is. With due respect to all nations, I have no biasness to any nation as such. It is ineffective. Why it is ineffective? The reason is there are internal differences between each other nation for individual, like governing difficulties, other economic difficulties, foreign trade difficulties, foreign exchange difficulties, technology sharing difficulties, technology gaining difficulties. So many inequalities are there. Unless inequalities are equalized to an extent, Like in India today, SC, scheduled caste, scheduled tribe, why they were given privilege of 13%, 17% reservation? Reason is they are suppressed for several years, and all of a sudden, if you say that they must be equal, it's impossible. So by that way, the equalization concept must be bridged, and that role should be carried by the who is that SARC office or SARC group. So for that, who will take initiative? We are also part of. From our side, as an academician, today we are proposing. So tomorrow, maybe General Secretary office may take note of this point. Tomorrow, if it is published in newspaper or by other means, if they get to know, they may think about tomorrow. A committee may be appointed for SARC nations. Differences can be the factual IPR differences can be identified, and by each of our member can be contributed, or any national reports can be contributed, and by that way, then efforts if it be made. My meaning is all the nations, with due respect, the equal enjoyment of this technological growth can be benefited. Like one country is working with 5G, another country is suffering with 2G, 3G in our SARC itself. If you look about all the 7 nations, and we are having another observing countries of another 10 list is there, right? So those countries are also willing to join us and make our development sharing also with them. So in that manner, if I mention who all the countries are interested to just join in, even though we are not interested, we are not persuading it properly, because effectively not that way front rolling of the factors reason. So it is a very leisurely working ahead. So by that way, what I want to convey here is, if you see, like already we have these nations: Afghanistan, Bangladesh, Bhutan, India, Maldives, Nepal, Pakistan, Sri Lanka. This is known factor. But now observing nations, observing states are Australia, China, European Union, Iran, Japan, Mauritius, Myanmar, South Korea, and United States. They are in line of observation. And the other nations who are expressing their willingness is Indonesia, Jordan, Canada, New Zealand, Ireland, Saudi Arabia, United Kingdom, Yemen. So these countries are also eagerly interested to do business with the SARC nations, with this regional coordination effort. So that means there are benefits. These nations are not mad enough to coordinate each other. Rather, they have reasons to coordinate. When these many nations, some of the nations are on the world top list, no? Like the mentioned list I just referred is, like United States is also working now seriously with us under observation list. Why? Because now Indian business also majorly, if you see the world business, I'll give some glimpse of this information. By that way, you can understand the significance. If you see the world business as on today, somewhere around 200 trillion. So when it is $200 trillion of business is happening across the world, how much US is contributing? So around 17 trillion. How much India is contributing? Around 4-5 trillion. China is also somewhere around 6-7 trillion, or line that. And other nations are also, Japan is also around 5 or 4 or 5 are in, I think. Right. So in this count, these top 10 or 15, 20 nations are contributing 50% of the world economy. If you see in developed countries, how much IP is contributing in their economy, as per that index, how many universities are there? Yes. Why? Because today these intellectual properties are developing from where? Academic institutions. How many institutions are there in the world? Across the world, we have 30,000 universities. Astonishing fact I am expressing here. You can check it in net also. In the world, India is having the highest number of universities, somewhere around 5,500 and odd as a country. America is also having only 3,000 universities. But in looking into this comparison, most of the time when we study in academics also, we take one side America as a country, because 50 nations become one nation with federalism, and by that way they are working, even though there are 50 countries in division, but still they are working in a group of structure reason we consider as a nation. Whenever you see France never come individually, Germany never come individually, earlier England also never used to come individually, rather they used to claim as European Council or European Union. So European Union is having how many countries? 27 countries. So 27 countries group is nominating and respecting and comparing with that. But India, even though having 29 divisions with some states and some union territories other way, right? So by then also we are working in collective form of a nation indication. But when you compare in many of the privileges, our ranking is 42 or our scoring is, if you see independently patent working, India is on 7th position or 6th position, right? In largest count, if you look in, their economy is reaching on the 3rd position or 4th position of the patent working in the world, right? The largest means the quantum of application receiving was somewhere around 6 lakh applications or the 12 lakh applications in China, and in America 6 lakh applications. India is having effectively 1 lakh above applications last year achieved. So today, this 1 lakh applications, if you see in 12 lakhs, how many patents are effective? China, 70% patents are ineffective because they are not non-workable condition. Their economy is not producing that much level. So by these reasons, effectiveness calculation, if you just specifically be derived, you will find that India is also one of the top nation in the world. That way, that means Asian region, South Asia is also equally significant enough. For that, one more point also I can figure out here. What it is, if you see world across biologically rich segments, there are only 40 biological rich spots, of which Asia, South Asia is one of the richest golden spot. Golden spots are 20-25. Out of the 25 also we are being listed. So that means whole world is in need of the assistance or the sharing of the South Asia all the time. Not only South Asia and ASEAN is being blocked. Then many of the resources may not be gained by the world at large. So that's why ASEAN, now Myanmar is already there in ASEAN, because we rejected to have their membership in South Asia. But today they are eagerly asking to make them as member in South Asia. So likewise, other nations are also equally eager to join into us. But my basic input here to express is the regional coordination requirement is highly essential, is the effort which I try to keep all the statistical data and other inputs to keep in. But other way now, how regional coordination will benefit for individual nations. I'll give 3 examples, and by that way, I'll try to come to the, okay, my time is up already. Okay, within 1 or 2 minutes with this input, I'll close it. Is it okay, madam?
Yes, sir. Yes, sir.
Right. So by that way, I'll just now mention these 2 points. Why? Because like Bengal region. So Bengal region falls under Bangladesh or in India. Both the places are equal, like West Bengal, East Bengal. So these 2 places are having, and geographical region related division, when we are gaining, Bangladesh is gaining. This internal silly fight is making damage for world market. In world market, whether what is that fish, Hilsa fish. So Hilsa fish is having world demand. Whether Bangladesh, East Bangladesh is also having the same coastline, and West Bangladesh is also having the same coastline. So both are equally entitled to work with the same. It is the collective benefit of both the regions. If we had a common relation to each other, similar way Sindh province, whether it is Punjab, Pakistan or India, so they are also having the province together, and by that way there are some peculiarities and their geographical privileges are there, which is related to both the territory to be benefited. So in that way, if we ignore the differences and make the common benefit to the world at large, by that time both the countries can equally benefit, rather than we are disputing to each other, third party is taking the benefit for their interest. So that's why these things requires to be keeping ahead of our ego differences or regional differences. If we able to reach out to such kind of settlement between, like even within the country also, why I should say outside the country, within the country also, today Marwad region is limited to Rajasthan alone, or Rajasthan, Gujarat and Punjab is equally having the sharing. It is there. Like Rasgulla period, we saw regarding to Rasgulla also, Orissa and Bengal was having this difference, and now 2 different identifications given, and by that way started. It is not possible in every case. So now today, Magua Desi liquor, that means the local drink, is having a fight between 12 13 states, because all these regions this is equally working. Likewise Litti, likewise other, there are many other components are there for GI dispute happening. I'm taking one example to give the input to understandable factor reason. So by that way, these differences we must salute by our regional level of workable efforts, and it is a historical fact that they are together and they have entitlement to share together. Like Mukesh Ambani and what is that? Anil Ambani. They are the sons of Dhirubhai Ambani. Reliance shall be shared between both the parties. One cannot say that because other person is economically weak, I should only be used and other person cannot use. It is his natural right. No one can deny it. Anil Ambani, whatever losses he sustained, still he is entitled to have the trademark utilization by himself. So by this way, I say that there are so many requirements, and already proverb says that collectiveness gives strong efforts. Right. So in that manner, our rather than finger, fist can do better exercise. So by that way, all the seven SAARC nations put together can do wonders of the world. That is my intention, and by that reason, I congratulate once again the organizers for making this effort, and we must take ahead this effort furthermore and make out this fruitful. And let us make a summary report of this and submit to the General Secretary Office of the SAARC. By that way, they may take note, and subsequently they may give an opportunity for us to work further. So I am looking for that development, and I express thanks for all the people who are patiently listening for my words for this much time. Thank you. Thanks for giving me this opportunity.
Thank you so much, sir. Now we move ahead with the interactive panel discussion and open forum. This session will bring together all the panelists to collaboratively discuss actionable strategies for regional IP cooperation and will definitely answer your questions. We do have a few questions. So, if we begin with the first one, we have what unique IP challenges do small island nations face due to their reliance on tourism and traditional crafts? We may begin with Fatima ma'am, and the other speakers can join her if that is possible. Ma'am, you are on mute. Pankaj sir or Murthy sir, if you would want to start with the answers.
Yes, handicrafts, isn't it? The subject here is handicrafts. Most of the time, it is noted that this may fall under GI, geographical indications, and already there are several GI handicrafts items we have. So the challenge is getting registration of GI so that we may protect it adequately under IPR system. Identification of such potential handicrafts for the GI purpose is easy, but it's not so easy to get GI registration. Again, there are some challenges. One of the challenges is society formation. So there is hardly some sort of association for the welfare of all the. So again, the problem is sometimes there are only few persons for their vested interest from some sort of organizations somehow manage the GI registrations. Again, this purpose of all the stakeholders, the people who doing such handicraft business since long. Another challenge is many times it is noted that for the public welfare, some government agencies take the lead and try to register GI under that office, some government offices. So ultimately, this is the job or duty or responsibility of the association of that person only. They don't have their own society, or maybe they have multiple society and no one taking care of that GI tag. So it's not the job of government office. So they manage the GI registration, but again the challenge are adding further members like authorized users, promoting that business, making export of such handicrafts item. So there are several challenges for this handicraft side. So this is one of the aspects for GI. There are other challenges maybe for patenting or trademarks or copyright, but most
So there's some network issue at your end. So we are unable to hear you.
okay. Actually, I'm able.
So we are still not able to hear you.
I don't understand why it is mute again and again automatically.
So we can hear you now.
Okay. Actually, I'm saying that most of the time the concern IPR is GI for such handicrafts item, and the challenge associated are the society, the association of that person who needs such a GI protection. So sometimes government agencies take the lead and register such GI. But again, this is not the work of such government offices. So ultimately, the person need to form some association and take over such GI work from the government agencies. And many times they are hardly much authorized users registration under that society. So ultimate purpose of such GI can't be fulfilled because we have to add maximum number of such related persons who doing such business since long or since generations. So there are so many cases. You can check GI portal itself. There is hardly much GI registrations there. So the purpose of GI itself is to give maximum benefit to all such persons who doing such business since generations. But this is not happening. So there are some challenges. So that's all. Some speakers may contribute further in it.
Nalin sir, we do have a question for you. The question says, how can regional cooperation frameworks such as the SARC be utilized to address cross-border IP violations effectively?
Yeah, so if SAARC countries are at least having some agreement that if violation of any SAARC member's product or SAARC members' intellectual property rights are done by any other non-SAARC members or outside the SAARC region, then it is better that individual countries, instead of individual countries fighting against other individual country, if region as a whole is having a consolidated effort to say that this is not only the product of Bangladesh or Nepal or Maldives, but this is a product of SAARC region. You cannot do like this because we have the agreement among the countries that under this clause, under this article, we all are united to uh, basically to protect the intellectual property rights of any member countries of the region. So tomorrow, smaller countries in South Asia, for example, Maldives or Nepal or Afghanistan, if they have some type of problems in their IP infringement, they will have a larger support from other countries in South Asia. So the voice of those smaller countries can be also supported by the voice of other larger countries of South Asia. And this will not be a individual country's problem, but this will be a regional issues. So through this regional cooperation for the intellectual property rights can be also strengthened, and other regional blocks, other countries of the world can also see that uh, if we are not basically protecting the rights of South Asian members, then we are losing the South Asian market. At the same time, if something is happening in South Asia, some infringement is happening by other countries in South Asia, South Asian countries as a whole should object such infringement, and they should also take note that this is not the infringement happening in one country, but this is the infringement which we have to stop in the entire South Asian region. So, making South Asian region as a strong case of intellectual property protection is the need of hour, because if that is happening, then we will have lots of positivity in receiving IP investment, and we can also establish our identity in the world, that it is not like we uh, cater the only the individual's agenda, but we have the regional agenda to cater, and we are basically one at the region level. So that is the point.
Thank you so much, sir. We do have a question regarding sustainable development goals. I would request Murthy sir to answer that. And the question goes like, how can IP policies be tailored to support sustainable development goals in the South Asia?
Right. So I have few points to share in this regard. Very right. In sustainable development goals, now the 17 goals, if you look in, there are specifically 4 or 5 goals is directly related to IP specific. IP infrastructural development, goal number 3, 5, 9, 13. I think these all numbers are directly related to the sustainable development, because what is that 2030 का means जो attained the set goals, they are likely to, these 17 goals are majorly on pollution control and regulation and infrastructural development and intellectual development. So intellectual development in last century, it happened without any restriction, but now these restrictions, now the underdeveloped countries to come up with these difficulties is a very challenging task. Even developed countries also not able to comply many of the things, and that's why they are just making variations and excuses. So by that time, this regional coordination, like Ms. No, my Professor Nalin very rightly said that, yes, instead of fighting on individual basis by small nations, if it regional group, like if you see in DSB, most of the cases, dispute settlement body, most of the cases are raised and coordinated by European Union. So EU says that you file a case where either one nation problem or the community problem, whatever it is, they just try to come out and work out on the regional level. So out of that 27 nations working as one person representation. Out of 27, one country take one responsibility, kind of division they distribute, and by that way they can effectively coordinate and protect their regional interest highly. That's why EU is now on the top of any of the regional coordination. So in that regard, sustainable development is set for every nation to comply. If individually look upon, like Afghanistan is yet to develop the legislative framework. So for that, people who are already expertised and learned in the regional level, they know what is the challenges and difficulties. So that country is able to assist them effectively, rather than from an American coming and just making an assistance. So this will make a difference to Afghanistan. If America come and help to Afghanistan and India help to Afghanistan, it make a huge difference between American support and Indian support, right? So India can understand the local difficulties and regional challenges, and by that way, taking care of all the internal requisites, they can make a better, stringent, tailored legislative structure, and that will be more effective to stand at the international level as well. Compliance of international standard of compliance. So in that way, these set 17 goals also need to be imbibed in the legislative structure. Like if you see in our SAARC nations, they are trying to, at least after 94, all the nations started efforting one by one, and even till date, after 25-30 years now completed, 94, 2004, 2014 and 2024, 30 years completed by TRIPS agreement. So after 30 years also, still there are countries in SAARC itself is got extended up to 2033. Bangladesh is also one of the country, and Bhutan, Nepal is also there in that process to work out. So they have extension of time to comply completely. That's why enforcement mechanism is very weak in that condition, is the indicators mentioning. At least Bangladesh on the list, but Nepal, Bhutan could not able to make a rank. So reason is that the establishment is not yet completed. So India is at 42nd rank as per their 55 nations, top 55 nations indication. So these indicators are showing that we are moving in a direction, but instead of individually moving, if we collectively move and help each other, we can be taking the challenge of the world difficulties in one go, and that will be easy for all of us. 7 nations put together in a go, that will be beneficial, and we can easily attain the sustainable development as well, because most of our development is now taking direction of this sustainable growth in mind, and energy development also now India is widely working like in one way, whereas Nepal is rich with some of the resources, Bhutan is having rich with some resources, Bangladesh is rich with one resources, and India is rich with one resources. So if we together work out there, the resources can be equally benefited and intellectual sharing can be benefited. Instead of using 100-year-old technology by one nation and 100-year advanced technology is one nation doesn't have resource reason, they could not use their technology. Another one, resource is there but technology is not their reason, they also could not benefit it equally. So ultimately both are losing. So if both are connected, then we can make the benefit to both the people together. So that is the way how regional development will help us in working better. Not only that, a regional center, if we make a nodal point of working and we are distributing the work among our group nations, so that will also help. Say for example, internal fights and disturbances, how it happen. So Bangladesh is doing now cloth fabric manufacturing to the Western world majorly. So in between, what happened now, the because of internal differences, what we are doing is, so when India is capable enough to drag in, so we are fighting each other. Reason whose market? European market, Western market. So Western market, if you do or I do, how it make any difference? Rather, we both collectively do it together. So that will be benefiting to the world at large. By the same time, regional work distribution also be happened, resource distribution also happened. Another part can be taken by another part of the group. So that way, cooperation is better than fighting each other. So sustainable development achievements also can be successfully attained, and regional coordination can be helpful in making these differences to take away and reach out to the better achievements. Otherwise, this market may driven tomorrow to some other continent also.
Thank you so much, sir. Now I call upon Ms. Soumya to read out the written statement given by the speaker from Pakistan, Dr. Aziz. He was actually the speaker for yesterday's discussion, but unfortunately, due to heavy network issues, he could not join us. And he has submitted his written statement, which I would like Ms. Soumya to read out for us. Soumya, over to you.
Thank you, Priyanshi. So, as a nation on the front line of climate change impacts, Pakistan has faced devastating consequences of environmental degradation. The 2022 floods displaced millions, destroyed livelihoods, and caused economic losses exceeding $30 billion. We cannot afford to ignore the urgency of climate action. However, action demands equitable access to green technologies, an area where intellectual property rights pose significant challenges for developing nations like ours. Intellectual property barriers and technology access, in that the existing IPR framework often limits the dissemination of critical technologies that can mitigate and adapt to climate change. Advanced economies hold patents over key technologies such as renewable energy systems and carbon capture mechanisms. These monopolies inflate cost, making it nearly impossible for developing countries to acquire and deploy them at the required scale. Pakistan also believes that the current IPR regime, while essential for incentivizing innovation, must be reformed to balance public and private interest. Addressing climate change as a global responsibility and technology cannot remain an exclusive commodity when it is crucial for collective survival. Now, let's look to the way forward. First is technology transfer mechanisms. The developed nations and international organizations must establish technology transfer mechanisms that allow the sharing of patented green technologies with developing countries. Pakistan calls for a global fund under the auspices of United Nations to subsidize technology access for vulnerable nations. Second, we have is flexible IP provisions. The TRIPS agreement under the World Trade Organization provides for flexibilities such as compulsory licensing and patent pooling that allow governments to bypass patents for public welfare. Pakistan also urges the global community to extend such provisions to climate technologies. Third, we have is collaborative innovation models. Public-private partnerships and open innovation platforms can encourage collaborative research between developed and developing countries. These initiatives should focus on creating accessible, affordable, and scalable solutions to climate changes. Next, we have is Green Climate Fund utilization. The Green Climate Fund must prioritize financing for technology acquisition in developing countries. Additionally, Pakistan also recommends including clauses in international climate agreements that mandate technology sharing as part of mitigation obligations. Pakistan's commitment and role is committed to contributing to global climate action. Despite contributing less than 1% to global greenhouse gases, we have initiated policies such as Billion Tree Tsunami and the development of renewable energy policies. However, achieving broader goals necessitates international cooperation and equitable access to technology. Thank you.
Thank you so much, Soumya. Now, as we move towards the conclusion of this session, I would invite Mr. Dipendu Das, Director of CDIPR, to give us the key action plan and then deliver the vote of thanks. Over to you, sir.
Thank you, Priyanshi. And before moving ahead to the conclusion of this enlightening roundtable discussion, and hereby the discussion, the most awaiting discussion session which we held in the South Asian Global Intellectual Property Summit to 2024. In a very short time frame, we were able to gather the distinguished professors and the faculties of these South Asian nations. I'm very grateful to all the faculties present here and who have been contributed for since month. So the key action points which we took out from this roundtable discussion, I'd like to point out 5 key action points which would be submitting it to our the SARC secretariat, and also as Dr. Professor Murthy has already stated that we should submit recommendation, and also we'd be forwarding it to the Ministry of External Affairs regarding these suggestions points along with the DPITs. So the first point of action plan which we should consider is the need to establish a South Asian intellectual property alliance, like a group which would be looking forward for the IPR specific related development in the South Asian region. Most of the speakers from the countries around South Asia has recommended that. Even we today saw the recommendations of Professor Murthy along with Nilensa and like Mr. Pankaj has also discussed regarding this, that we should have this kind of suggestions to collaborate and work accordingly. The second is we should emphasize the importance of training programs for the professionals to bridge the existing gaps in IPR enforcement. Yesterday, when we were having these discussions, Professor Dr. K. Shamla ma'am has already emphasized that what are the key challenges which we faced. Like the major challenges, it's not the infringement, it's of the lack of awareness. So the awareness training sessions has to be provided in a wider scale. In a South Asian region, we see more lack of awareness, and for that purpose, a capacity building program, it's one of the key action which, as a South Asian nation, we should take collaboratively, collectively. The third points of the action point is the ensuring the startups and innovators to utilize intellectual property mechanism effectively to protect their innovations. When we see like the countries like Nepal, Bangladesh, and other like Pakistan, these countries are not having much effective registrations when we talk about the innovation, specifically the registration of patent. They are more focused towards the registration in trademark and copyright. So their innovations, their patent working mechanisms should be more effective. The people have to be more aware regarding their registration mechanism in the innovation segment to protect the innovations and also to promote it. So we should foster innovation ecosystem. We should provide more trained collaborative programs in regarding with patent innovations and how to protect thereby their innovative identity as well as their innovations to bring up the entrepreneur and to boost the economy of the South Asia. Fourth, the policy harmonization, as we also discussed policy harmonization on the yesterday's discussion, where the speakers have deliberated upon that South Asian nations can come up with a policy framework like European Union. So, in order to minimize the time of protection and to have the protection while the application process. So, advocating for the uniformity in the IP laws across South Asia to promote collaborations and ease cross-border challenges. It's one of the most important action plan. If we see like this is one of such point which the European Union has taken up while they were in the rush of development for being a developed nation. And the last point, which has been raised by many speakers throughout this summit, even in our guest lectures from Nepal and also Sri Lanka, that's the digital initiatives. We should take up with many initiatives to boost the IP collaborations in a digital ecosystem, and we should streamline the process of regional collaboration in a digital zone. Specifically for a countries in South Asia, we are not aligned towards the digital programs. Like this initiative, which we generally did this time, is to boost up a complete digital program in a virtual meetup. So this type of programs have to be initiated, and further it will not only reduce the cost of coming up together and conducting this session, it will also enhance the digital growth of each countries to come up and provide their opinion and to move with the dialogues between the nations. So coming up with these 5 points, it would be our recommendations and the concluding remark for all the South Asian nations that that it's the high time that we should foster inclusive and sustainable intellectual property. As rightly pointed out by Professor Murthy sir regarding the global innovation and the sustainable development goal, this is the time to come up with the sustainable innovation and to promote SDGs. So coming towards the vote of the thanks, I am very grateful towards the organizing team, like the people who had been conducting this summit for a month. The team of dedicated members headed by Priyanshi and his and Soumya, Dia, and many more. There'd be many people to name. So like I'm firstly thankful to all of you for being the key person who have conducted this summit thoroughly, and later the connectivity to all the speakers in a very short time frame. The speakers, we were able to connect with the speakers, and I'm very thankful to Professor Dr. Shamla ma'am, who have just in a very short time frame confirmed to be the chair of the summit, along with Dr. Muhammad Tohidul Islam from Dhaka, Bangladesh, Professor Dr. Amaris Murthy, Professor Aziz Ur Rahman from Pakistan to confirm and participate in this month-long summit, Professor Dr. Arhan Sthapit from Nepal, Professor Dr. Nalin Bharti from India, Professor Dr. Pankaj Kumar from India, and Miss Uza Fatima from Maldives National University, and Professor Dr. Manjula Sindhi Grima from Sri Lanka. So, in a very short time frame, all of you were being able to like accept an invitation and join for this collaborative discussion. This was our honor to host in this South Asian Global Intellectual Property Summit, along with to have this such a robust discussion on each of the specific topic in our guest lectures, where dedicatedly each of you has deliberated upon your viewpoint. Further, for a countries like Pakistan, where the diplomatic relationships is not good enough with the India, that too in a very short time frame, the Professor Aziz ul Rahman has accepted our invitation to be the part of the summit. It's one of the most appreciating and enlightening part to being the part of this exclusive discussion and also to organize it. Coming forward, we are very delighted to also announce that the International Journal for the Development of Intellectual Property and Research will be launched in January 2025. And all the guests would be the editorial board members. We'd be also inviting all of you to be the part of this international journal, which will be launching it in 2025. We humbly seek cooperation and active participation from all our distinguished guests and collaboration from the South Asian nations to make this endeavor a grand success, and together to create this journal, not only a part of academic reflection for our organization and also country, but in an overall view, a collaborative point for the South Asia to contribute throughout this nation. Along with this, I thank all of you for your presence and contributions, and wish one day we'd be sitting together and have this discussion in a very physical mode, along with our diplomatic ties and delegated discussions, and to boost this development of South Asian intellectual property. Thank you. Yes, Priyanshi, over to you.
Thank you so much, sir. Thank you, ladies and gentlemen, for joining with us for this roundtable discussion. I would request all of you to please be in touch with us through our social media platforms to be aware about the activities that we are going to be holding as part of the South Asian Global Intellectual Property Summit 2024. Thank you, everyone.